Hi everyone, welcome back. Today's the final class I want to give on perspective, so we want to get an understanding of exactly what we're doing and how we're going to do it overall, and basically who we are. So we're going to build an approach style. So if you look at the previous videos, we want to understand what a court is, what sovereignty is, what politics is, and we understand that we are the ones that have to take the action. We are the ones that have the power, and we are the ones that are in control. This mindset has to be with us. We have to know this. We get our power from the Constitution. We get it from the third article, which is judicial power. That's for us. No one's going to tell you that. I'm going to tell you that because no one else is going to. No one in the media, no one in the Congress, no one in the administration. This is the power that we have that is derived from the Constitution. Now, once you know that, then you know who you are. You know where the power is, and now we're going to move forward on how to use that power. Okay? Now, the interesting thing about it, we've been talking about judicial power, but before we can get to the judicial power, we have to exhaust the remedy. That's what they call it. Exhaust the administrative remedy. So there's a doctrine, and of course it's in the Black's Law Dictionary, and it comes under the exhaustion of administrative remedies. So it's under E for exhaustion. I call it the doctrine of exhaustion of administrative remedies because it's a doctrine, but it comes under E, not D in the Black's Law Dictionary. So here's what it says. This doctrine requires that where an administrative remedy is provided by statute, relief must first be sought by exhausting such remedies before the courts will act. The doctrine requires the party to use all available agency administrative procedures before resorting to the courts for relief, and requires that a party not only initially raise the issue in the administrative forum, but requires the party to proceed through the entire proceeding to a final decision on the merits of the entire controversy. Okay, so we know controversy is the key word. So we have to administrate the controversy before we take it into the judicial arena. So what does that really mean? To me, it means that the agency is represented by the agent. So when we come in contact with an agent, then we are engaged in the agency, with the agency. And there may be remedies that are available that are non-judicial. Even though that executive agency may do some judicial functions, it's not really judicial power. These are the way all these the branches work. Sometimes they have to exercise other powers, but only for administrative reasons. So executive powers using judicial functions to keep their system going. And so the executive, or any agency under the executive, does have a process that's judicial in nature that it needs to be exhausted before we go to the courts. So my take on that is, if we're stopped by a policeman and he comes to their window, then we're now engaged in a court, an administrative court, and we have two parties with accusations. However, when the officer walks up and initially approaches, the first thing he usually does is ask to see our papers, the driver's license and registration. Now, if he asks for that, my administrative remedy to him is, where are your papers? Because he's making me feel insecure the minute he walks up and says, I want to see your driver's license and registration. So I'm telling him I'm not secure. I want him to have a warrant so that he can see my papers. because I'm not sure why he's coming up to me. Now he's going to say he's coming up to me because of something he saw or some violation he saw or something he thought happened. But I'm not aware of that right now, and that's not what I'm concerned about. What I'm concerned about is his actions. So the minute he comes to me with an action of requiring to see my papers, I have to see his papers, because the law, that's Constitution, that he agreed to go by was the Fourth Amendment, saying that I need to be secure, and if I'm not secure, he needs a warrant. So when I ask him for the warrant, he's going to respond back and either say that he's going to go get one, or he's not going to go get one and he doesn't need one. Okay, and this is the initial start of the administrative remedy, because if he says he doesn't need one and I think he does need one, we have an issue. So I would ask him to bring out his supervisor to act as a magistrate to hear my complaint against him. And remember, this exhaustion definition says that that the party has to use all available agency administrative procedures before resorting to the court for relief, and requires that a party not only initially raise the issue in the administrative forum, but requires the party to proceed through the entire proceeding. So once I initially call for his supervisors, I'm going to complain to the supervisor that he's not conforming to his oath and to the Constitution, and he's violating my constitutional right. And so this agent that comes out is going to have to take one side or the other, either my side or his side. And if he takes his side, then we'll go to the chief of police to act as the judge. Because we need a remedy. We need a decision from the agency. He may come up and violate my right, but we need the agency to determine if he violated my right or not. That's all we need. So the supervisor will decide, is he on my side or the other agent's side? Then the chief of police is going to decide, and that's going to be the final administrative process. So whatever the chief of police decides, it doesn't matter whether he decides that I'm correct or the other side's correct or his agent's correct. Then we have a decision that if I don't like it, I can take it to the court. And if they don't like their own decision, they can take it to the court. So once we get a magistrate or a supervisor of some kind to make a decision that's final, then we can go to the courts. And this is what's preventing a lot of people from getting their remedies in court, and the judge denying all their stuff is because they didn't exhaust the administrative remedy. And so that's what we have, the doctrine of exhaustion of administrative remedies. We have to exhaust that remedy. Now that remedy is to establish what the facts are. Okay, and so this is the investigation of what the true facts are. They'll be established in the administrative remedy, so then we can take it to the courts to decide. And those facts will be looked at, and then we can apply the law to it. And we know which law we're going to apply to it. So they are not going to want to make that decision at the administrative level, because they're going to have to stick with it when we move into the courts. And that's why most of the time they're forced to make those decisions. They don't make them, so they're covered in the courts. So that's the key, exhaust that administrative remedy so we can go to the court and have the facts already established and not get turned away because we didn't exhaust the remedies that we had before we go to court. And next time we'll talk about the law and the facts and how they're adjudicated once we do get to the court. Okay, thanks a lot. Talk to you next time.